Well, this is an interesting one. It took me a while to find this on the news. Yeah, because well, I saw on the news, but it took me a while to find an article on this one. I tried looking at like 4 or 5 news agencies, and they didn't have it, so I decided I'll just type in, you know, cheerleader wins case for his free speech, and sure enough, it popped up. I did see this on right here. So here we go. U.S. cheerleader wins free speech case against her former school. Check this out. Okay. The U.S. Supreme Court has ruled in favor of a teenager who was kicked off of her school cheerleading squad over a profane social media post. In an 8-1 ruling, it concluded that the Mahoney area school district had violated Brandy Levy's freedom of speech under the First Amendment. The justices were asked to consider whether public schools had the ability to regulate off-campus speech. The case affects free speech rights for millions of American school students. Miss Levy, now an 18-year-old college student, was previously a member of the junior varsity cheerleading squad at Mahoney Area High School in Pennsylvania. In May 2017, when she was 14, Miss Levy made a Snapchat post after an unsuccessful tryout for the school varsity team. She uploaded while at a convenience store in Mahoney City. The post featured a picture of her and a friend raising their middle fingers with a profanity-laden caption voicing their displeasure at cheerleading, school, softball, and everything in another post. She questioned another girl's selection to the cheerleading squad. There's other pieces like that. Oh well. The post was screenshotted by a friend and shown to another pupil, who was the daughter of one of the cheerleading coaches. As punishment, Mahoney area high school coaches kicking Miss Levy off the cheerleading squad for a year. She then sued the Mahoney area school district, arguing that the decision breached her First Amendment right to free speech. With Miss Levy's case reached the Court of Appeal last year, the court in Philadelphia ruled in her favor, and the school district decided to take its case to the Supreme Court instead. It argued that the staff commonly take action against pupils for speech and actions that happen off campus, and that this power is important for tackling bullying, racism, and harassment that occurs on social media outside of school hours. But the American Civil Liberties Union, which represented Miss Levy and her parents, argued that the students need to be protected from censorship and monitoring. In its decision, the Supreme Court concluded that Miss Levy's right to freedom of expression, protected under the First Amendment of the U.S. Constitution, has been violated since the social media post did not cause substantial disruption at the school. The vulgarity in BL's post encompassed a message or expression of BL's irritation with criticism of the school and cheerleading community. Justice Stephen Breyer wrote in the majority opinion, using Miss Levy's initials, the school's interest in teaching good manners is not significant in this case to overcome BL's interest for free expression. But the court added that the school still had a significant license to regulate students' free speech in some off-campus circumstance. It said it would not categorize define in what the school related off-campus activities this meant. Ms. Levy said in a statement following the decision, young people need to have the ability to express themselves without worrying about being punished when they get to school. I never could have imagined that one simple snap would turn into a Supreme Court case, but I'm proud that my family and I advocate for the rights of millions of public school students. Pupils' right to free speech in public schools is protected by the landmark Supreme Court case from 1969. Tinker versus Des Moines Independent Community School District, when pupils wore black armbands to protest against the Vietnam War. The court in that case ruled that the pupils' speech was protected as long as it did not cause material and substantial disruption to the school. But until now, it had not addressed how to handle school-related speech made by students off campus. Good for her. Like I said, I'm proud of her. I'm glad she took it to Supreme Court because you know what? Free speech is free speech, ladies and gentlemen. We live in the greatest country, and people want to censor free speech. I mean, you got this liberal, these lefties, all these, these snowflakes like that. And it starts with the Discord flunkies and the so-called people in the truth movement. They say they're about free speech. No, they're not. They're not about free speech. Free speech is about expressing yourself. You know, it's like, you know, there is such thing. In the SCOTA law and the Bill of Rights, it tells you there is no such thing as hate speech. You know, I'm not gonna go around saying, you know, be like, you know, dropping N-word or F-word like that. But you know what? I am entitled to my free speech. I can say on like drop a video, I can say this and that. And people want to get butthurt and they want to take you to court and they want to punish you by having you arrested, go to jail. It's crazy. It really is. Like I said, the First Amendment protects free speech, public photography, and a lot of things out there. And with that said, I'm out of here. Mike Chuck. Peace out.